lecture. Welcome here. Welkom by Stellenbosch. It is my pleasure to welcome you to this annual Intellectual Property Law public lecture. And in particular, I'm very pleased to welcome our speaker, Gail Schimmel. Welcome here. We're looking forward to your lecture. And I would also like just to specifically mention or acknowledge the following people who are here. Representatives of the founder and current funder still of our chair of Remgro and the Richmond groups. Anton, Vice Dean at our sister faculty, UCT. Colleagues from IP practice and academia. Our sponsors, Von Seidels, and Eric will say a few words after me, and all the other members from Von Seidels. Our former chair, Professor Owen Dean, welcome here. And then all other friends, colleagues, postgraduate students, undergraduate students of the Faculty of Law, you are welcome. I want in particular tonight to make the exception to say a special word of welcome to our own colleague, Professor Sadullah Kajika. We are all very happy that Professor Kajika is back in the country. He's currently on sabbatical and he's enjoying a research leave at Oxford University. He only arrived back yesterday, and Sadullah, from our side, we're very happy that this lecture also continues in your sabbatical year. Thank you very much. This year is the 7th annual public lecture in IP law. The first one was hosted in March 2013, and the speaker was Charles Gielen. And last year, if I remember correctly, it was Professor Christoph from the Munich Technical University. Our faculty and chair are extremely thankful for all the support that we receive, the sponsorships, this other support of all our colleagues and sponsors. It really makes events like this possible in a university sector. So really, heartfelt gratitude to all of you. Like last year, I want to remind you that according to our chair for intellectual property law, innovation, creativity, novelty and ingenuity are the foundations of intellectual property law. So very fittingly, tonight's lecture has to do with new and changing roles of advertising in IP disputes. I'm very much looking forward to this lecture, and I also hope that you will enjoy this evening with us, also the refreshments afterwards. And on that note, I hand over to you, Eric.
Thank you very much, Professor Smith. Good evening, ladies and gentlemen. It is a huge honor for us, Von Seidels, to be here tonight and to be able to help you or assist you in presenting this event. We're honored, and while we're all looking forward, like you, looking forward to getting some food for the thought and mind, particularly from Gail later, we're just grateful that we can assist with giving some nourishments to your bodies as well. Professor Smith, Professor Kajika, distinguished guests, we thank you for this opportunity to present with you, and we cherish our long-standing relationship with the University of Stellenbosch. I went around the office this afternoon, and I found that no fewer than 20 of our attorneys are alumnus of this university, which is more than 50% of our attorneys, which we think is fantastic, and we love coming here. It's always good to come back home. I spent a good 5 years at the university, and it's always fun to be back. I was given a quick 2 minutes, so I thought I need to fill it up somehow. So on the topic, no time to be chicken. I think it's a fantastic topic. It's so relevant in the current IP landscape we find ourselves in. So I just wanted to mention 2 quick facts. Well, the one is a fact, the other is a bit of a story. Just proves that there is really no time to be chicken. Unfortunately, and this may bore some of you, but I have a bit of a bias towards patents and a bit of a bias towards numbers and statistics. So I recently just did a quick check and see what's happening in the world and what has happened in the world over the last 20 years. And particularly on the invention side, on the innovative side, finding people coming up with new inventions and protecting them all over the world. And I just looked at some numbers, and the USA has always been the leader in new innovation and filing new patents all over, well, particularly in the USA. So 20 years ago, 1998, In that year, they filed just over 200,000 US patent applications. 10 years later, in the USA, they doubled that number to almost 450,000 US patents. And still 10 years later, last year, 2018, that number grew by another 50% to 600,000 patents filed in the US alone. Europe had a similar trend, although the numbers were not the same, about a third of the US. So they went from 70,000 patent applications 20 years ago to 140,000 10 years ago, and last year was about 180,000. So also a significant increase. But then the big surprise came out from our colleagues in the East, from China. 20 years ago, they filed a modest 45,000 patent applications. 10 years later, they almost increased that 6 times to 300,000 patent applications filed in China alone. 10 years later, last year, they went up to a staggering 1.5 million patent applications filed in China alone last year. So there are lots of patents in the world, lots of chances for dispute. And we're hearing about interesting ways of dealing with disputes, not in the patent industry specifically, but IP in general. We're looking forward to that, Gail. Just interestingly, a couple of years ago, we hit the global 3 million new patent application filings per year. So that was some statistics. Some of it are scary, but it shows you also there's no time to be chickened. If you've got a good idea, protect it, pursue it, and go after it with everything you've got. And deal with the disputes later. The other one is a story. I don't know if any of you have heard of a guy called Keith Valentine Alexander David Bright Graham. It's the longest name I've heard in my life. He's more commonly known as Levi Roots. He's an American-Jamaican person. He started his career as a reggae singer, and then really enjoyed the Jamaican heritage, so started selling jerk chicken. I don't know if any of you have had that. It's a delicious Jamaican dish, fits in with the theme, no time to be chicken. It is time to cook chicken. And he started selling his jerk sauce at a Notting Hill carnival. He was discovered there by some BBC producers and asked if he wanted to appear on the show The Dragon's Den, which he did, and due to his charisma and his particular, he actually wrote a song for his jerk chicken sauce, which he presented on the show. He got funding to £50,000 for 40% share in his business, and he was one of the biggest successes after that in the food industry. His business is currently worth over £55 million, selling his sauces. And the interesting thing that I thought to mention is, what intellectual property did he have when he started his business? And the answer is none. So the real question is, why would an IP lawyer tell you this? It's like a turkey voting for Christmas. But the real reason for it is that there are registered rights, there are unregistered rights, there are things you can do, and I think the reality is there's no one-size-fits-all approach when it comes to intellectual property. There's a lot of value in good advice, good mentoring, a good product, some good investment, some good contacts, and some slick advertising. Why the examples? As I said, there's no one-size-fits-all. So we in the IP fraternity need to be creative, and we need to come up with clever ways of protecting, but also helping our clients deal with conflicts, deal with disputes. And we in the IP fraternity must provide tools for entrepreneurs to grow their businesses into successful established businesses, and for established businesses to grow their businesses into global empires. So we've all got a responsibility knowing a bit about IP. So that's my 2 minutes worth. What I also wanted to do is I wanted to ask Professor Kajika to just help me. We've got a small prize for one of you lucky people. We got all the people, everyone here tonight, Annette prepared a list for us. Everyone got allocated a number. We've got a number in a bowl. So we want to ask Professor Kajika just to draw a number from the bowl, and the winner will get a free consultation with one of our attorneys, plus a trademark registrability search, plus a trademark filing, and up to 2 classes. If you don't want to use it yourself, you can transfer it to someone else. All they need is that little voucher, and if they lose the voucher, just give us a call. It's still fine. Okay, I just want to get the ball.
Should I go?
You can't look though.
Well, I'm pretty blind anyway, so.
And your name's not in here. It's 36. So number 36 is Marius Basson. It's Marius Isson. Marius. I think it's over to Prof. Kajika. Thank you very much. Enjoy the evening. Thanks.
Thanks, Eddie. Of course, now there's a secondary market in von Seidel's consultations, so we're going to see how much that voucher trades for in the secondary market. But good evening, ladies and gentlemen. It gives me great pleasure to welcome you to the 2019 annual IP lecture hosted by the Anton Mostert Chair of Intellectual Property Law here at the Faculty of Law. We are delighted that we've had generous support from von Seidel's to put on an evening like this. And we're happy to see so many of our colleagues from academia, practice, other faculty, the head of mercantile law, our dean, our vice dean, who's otherwise engaged, but he will join us later. Thanks for being here, and it's encouraging that we have so many of our students attending, past and present. So welcome everyone. It gives me great pleasure to introduce our speaker for this evening, Gail Schimmel. Looking at her impressive achievements, you can understand why it is said that women can multitask. As you may be aware, she is the CEO of the Advertising Regulatory Board. And the board administers the Code of Advertising in South Africa on behalf of the advertising and marketing industry. It's a self-regulatory environment. She is an admitted attorney and a specialist in advertising law. Prior to taking up her position at the ARB, she ran a consultancy and has been a past director of ENS. As if that is not enough for someone so young, she has written a book on advertising law, and she is a published author of a number of works of fiction. So maybe she can tell us if having to discipline advertisers and marketers makes writing fiction easier. But what Gail does not know is that by agreeing to present the lecture tonight, she may be about to fall into a cunning trap. Luckily for her, it is within her own hands whether she actually falls into the trap or not. As you are no doubt aware, you are all young and impressionable. And you are gathered here because of one sole reason. And that is because of the marketing and advertising related to this event. You know, all the fantastic work Querbus and Annette did in marketing this event. You were told that it would be an interesting and stimulating lecture. So, whether we are accused of false and misleading advertising depends on Gail's performance tonight. So, if she does not want to deal with complaints tomorrow morning at the ARB from about 100 plus people, she will have to live up to the billing. Right? I know what you're thinking. This is pure genius. Right? So everybody needs a worthy adversary. So, Gail, I hope you can live up to the billing and sort of thwart my dastardly plan. But she has agreed to take questions. We don't take ourselves too seriously. The people we invite, we know, have something worthwhile saying, but we don't take ourselves too seriously, and Gail will be happy to take questions afterwards. Gail, it's over to you.
I'm just going to take a moment to get dressed, get into the mic, and attach to everything. Is that me making that noise?
Yeah.
Okay, I don't know if I can pull this off. I'm going to have to walk with that as I walk back and forth. I've also reached that age where it's a long time since someone's referred to me as young, so I got lost when you said I was young. I stopped listening to everything after that. I've hit that age where you don't know how to deal with your reading glasses because you've only just got them, so I'll be half doing this, and we'll see how I go with that. And let's now just check that I can work a pointer. Good, great to go. Okay. I have to tell you, and this is even worse now than it was when I originally prepared the speech, I'm not a person who normally formally prepares for speaking. I love to speak. I know my topic. I have a presentation and I kind of follow the presentation and I just talk. But tonight my instructions were so intimidating that here I am for the first time since my wedding 16 years ago with notes on what to say. And it just, I have to say, I thought that I was anxious before. After that introduction, I'm even more anxious. I have to make this talk as advertised, intellectual enough for the august academics in the audience. And I have to make it entertaining enough for those of you who've just wandered in the hope of free wine. I have to accept that there are undoubtedly people in the audience who know more about IP law than I do. And there are probably people in the audience who think that they know more about advertising law than I do. I have to hope that you leave here entertained and enlightened. I can't be too quick, but I can't be too slow. God, it is like my wedding night all over again. Tonight, I'm taking two words as our theme: change and courage. I will be speaking about these themes from a number of angles. I will speak about the new organisation, the Advertising Regulatory Board. That is a change that took courage from the industry players who were involved. I will speak about examples of the courage to speak truth. And I think that is something that is very core to us as South Africans at the moment, the ability to speak truth to politics, to the ability to speak truth in social situations, the ability to know our truth and to speak it when we need to. And I will speak because I know that many of you are actually here to get hints on how to win things for your clients. I glance at the sponsor as I say this. I will speak about using the ARB as an alternative to the courts and the courage of the lawyers who do so. And as has been said, I will leave ample time for questions because I know that as much as I cover, I probably won't answer the questions that you really want answered. I'm going to start briefly with the story of how the ARB was born, and this is something that I've spoken about a lot. It feels like I keep repeating myself about it, but I do think how we went from the ASA to the ARB, and please do note, I say the ARB, we are trying very hard not to become known as the ARB. So I feel like I've told this story a lot, but I'm going to repeat it again because I think it's important. The struggles of the ASA have been blamed on a number of things. And when I'm speaking to lawyers, what often happens is that people think that Herbix and the Herbix decision and the Herbix battle about whether or not non-members were bound by the decisions of the ASA is what destroyed the ASA. It didn't help, but that was not the problem with the ASA. What happened with the ASA is that the funding system fell apart. The funding system originally worked on a levy placed on advertising and collected by the media. And when it fell apart, what should have happened is that the ASA management should have stepped in and found another funding system. I'm not going to bore you with the details of how it fell apart. Suffice it to say, they should have stepped in, they did not. What happened instead is they continued to spend at a rate of 1.3 million a month. Inevitably, in October 2016, the ASA went into business rescue with 6 million rand in debt. In June 2017, and I have to get this right with my dates, I came on as the ASA CEO. I was presented with that 6 million rand debt. The bulk of it was to SARS due to a very unusual decision to stop paying over PAYE instead of downsizing. You know, makes perfect sense from a management point of view. And I had no funding system when I came on. By August 2018, we had drastically cut expenses. We had raised 5 million rand for post-rescue debt. We had set up a funding system, and that was bringing in 400,000 rand a month, and we had raised 2 million rand towards that pre-existing debt. The business rescue practitioners approached SARS as the principal creditor and made an informal offer to settle. SARS informally accepted that offer. The formal meeting of the creditors was called, and SARS rejected the offer, sending the ASA into liquidation. That is the story of what happened to the ASA. At that point, the industry had a choice. They could fight the liquidation. There were a number of legal bases we could have arguably taken to fight the liquidation, or they could save what was really important, self-regulation. And they took the courageous step that is what they would do. They were going to let the ASA go, and instead they were going to save self-regulation in the form of a new entity. So MASA, which is the Marketing Association of South Africa, IAB, which is the digital publishers, and the ACA, which is the traditional advertising agencies, came together with great courage, and they formed a new entity, the ARB. A new memorandum of incorporation, a new board, a new home, and nothing in the bank. And of course we had a number of legal challenges. We had the challenge of whether or not we could enforce our decisions. Luckily for us, the Electronic Communications Act was drafted in such a way that it recognized that there could be a successor in title to the ASA, and the ARB has the same powers over broadcasters that the ASA had. We had the challenge of whether or not we could use the code. I'm looking over this room. I suspect there's a strong chance there's at least one of you in that room is currently trying to have that fight with me. It is an ongoing issue, but we have strong legal opinion that the code belongs to the industry and that the regulatory body is merely given the mandate to apply the code. And of course we had the challenge of the Herbex decision and the fear that would come back to bite us as the new organisation. We have incorporated the wording of the Herbex decision into our memorandum of incorporation. Almost a year later, I think it is safe to say that the phoenix has risen. We have a direct funding system with the next 8 months already in the bank. We've received over 500 complaints. We've issued over 110 decisions. In exactly 3 weeks from today, we will be a year old. And here is the big achievement, and a room full of lawyers will appreciate this. We have not yet been sued. It's been a year of change, and it's been a year of finding and speaking our truth. The speaking of truth started a little bit earlier than we really would have liked. To be exact, with file number 26, when Mr. Sele complained about a very popular ad. I'm going to have to stroll over every time I play an ad and might lose my mic and pointer. Let's have a look at this ad.
And a long time ago, Big John left home to satisfy his hunger for adventure. His spirit was unstoppable. And his hunger was too big and Big John did many things, but he will always be remembered for discovering a foreign land. And that is the legend of Big John.
Now you see where we got the idea, no time to be chicken. Let me start with this, and I ask you to tell the truth. Speak your truth to me, so to speak. How many of you enjoyed that ad? Most of you. It's a popular ad. Who here thinks it would be okay to have an ad that makes a joke about the Holocaust? Nobody. Anybody think the Rwandan genocide would be a good basis for a joke in an ad? Nobody's finding that funny either. And this is what Mr. Selle did not like about this ad. It centers around a parody about colonialism. And colonialism is as painful, he submitted, as any one of those events. A Holocaust, a genocide, colonialism, they are up there in the great horrors that have been perpetuated on humanity. He said he did not want to be reminded of this in advertising. He did not find it funny. The advertiser, Chicken Licken, in fact agreed with him. Absolutely, it would be a shocker to make a joke about colonialism, but this ad is not about colonialism. Apparently, it's about discovery. The directorate agreed with the complainant. We said that the ad is indisputably about colonialism. It refers to Holland, 1650. It shows a voyage of discovery. It shows a man with a spear staking his claim on the ground. We said that there is no doubt it is about colonialism. And we said that while much of being a South African is about being able to laugh at yourself, there are certain things that are just not funny. The advertiser appealed. They appealed quite loudly. And the matter went to our first appeal committee. Just for those of you who do know a lot about ASA, ARB procedure, this is one of the changes between the ASA and the ARB, whereas we used to have two appeal committees at the first level, the Advertising Standards Committee and the Advertising Industry Tribunal. We have now combined them into one called the Advertising Appeals Committee. And this matter went to the Advertising Appeals Committee, where it was ably chaired by Advocate Gina Malindi. Time does not allow me to discuss his decision, but really, if you want a great summary of the state of freedom of speech in relation to commercial speech at this point in time, that decision is well worth a read. The AAC had a split decision. Advocate Malindi, in fact, had to exercise his casting vote as well as his deliberative vote, and they agreed with the directorate that there are certain no-go areas, that this ad is not funny. The advertiser appealed again, and it came before the final appeals committee, and Judge Bernard Ngwepe chaired that committee. What you see on the slides from now are extracts from the decision. At that hearing, the advertiser again went down the no colonization street. They said, it's not about colonization, it's a parody, and you have to laugh at it, it's very funny. The committee was not having any of that. They said, if it's a parody, what is it a parody of? You can't have a parody of nothing. It must be a parody of something. It's a parody of colonization. Therefore, the ad is about colonization. They allowed that in making a parody, the considerations of freedom of expression. But I think it will come as no surprise to this audience that they also said that freedom of expression can be limited by other rights. They did not agree that there are no-go areas in advertising, which is interesting and is going to be an interesting point for me to take forward. They felt there's not necessarily such a thing as a no-go area. They talked about the point that this was not exactly the material of a great intellectual debate about human rights. This was an ad for a hamburger. Is this the place to be doing what they did? And then they came to the point of their decision. They said that they believe that you can have a parody in an ad, and you can parody anything, but if you do so, you have a duty of care. In making the parody, you must recognize the negative effects of the terrible thing that you choose to make a parody of. So if you are going to make a parody of the Holocaust, you must also communicate how terrible the Holocaust was. And this is where they felt the advertiser went wrong. I have to admit, I'm not sure that it would have been a very fun ad if it had pointed out all the suffering caused by colonization. I'm not sure that they can amend the ad in a way that's going to make that committee happy, but it's the finding that we now go forward to in considering matters of humour, alleged humour, as the ARB. I've discussed this decision under the heading Speaking Truth to Public Opinion. And I must tell you, public opinion was not with us on this one. Not at all. Twitter, and particularly Black Twitter, does this audience know about Black Twitter? Any of you active on Black Twitter? We're not happy with us. We were attacked quite a lot, and we were told that we did not understand the ad, that it was a great ad. I found today, I was checking because I couldn't remember the name of the political party. Briefly, we were the favourites of the PAC. I never thought that I would be a poster girl for the PAC, but briefly there I was. And we were also told, and I found this lovely quote, that we'd been infiltrated by EFF crybabies. So nobody was quite clear on where they stood, but what we did get a lot was that we didn't get this ad, that we did not understand the black market, and that the complainant was accused of being white, he isn't, and of being a white person pretending to be a black person, and that it was all a big plot of white imperialism to take down this very wonderful ad that's about black people, and clearly it was done because everybody hates everybody. I have to tell you, I hate this ad. I feel like I'm watching a Leon Schuster movie, or The Gods Must Be Crazy, and I have all those uncomfortable feelings of white guilt that those movies make me feel when I watch them. I really, the more I watch this ad, the less I like it, but apparently I am not the target audience, and apparently the target audience loved this ad. And this led me to think carefully about the most dangerous forms of stereotyping. And the fact that often the audience being stereotyped are barely aware that the stereotype in the advertising is happening, because the entrenched narratives that are being used are so entrenched that we don't even pick up that that's what we're watching. Which segues rather neatly into the next truth that I would like to discuss, which is the speaking of truth to structural inequalities. When I have discussed Chicken Licken with people and tried to explain my position, I have used the example of women in washing powder ads. You all know that ad where the pretty housewife, she's always pretty for some reason, not aged by her children like I am. And it's always the woman, and she's always doing the washing very happily. And I believe that far more than a naked woman draped over the bonnet of a car, that this is the most dangerous message that we are sending our girl children, that they must do the washing and whatever else it is that's advertised that only women do. But we can't pull those ads, or can we? In the UK, that is exactly what they are starting to do. They've introduced a number of rules against gender stereotyping that push the duty of care onto the advertiser. You can use the woman doing the washing, but make damn sure that in the background the man is doing the ironing, or that there's a pile of the men in the audience laugh nervously, or that there's a pile of legal textbooks and some things from work showing that she's not just doing the washing, she's also a successful career woman. Let's have a look at two examples, gather my stuff, of ads that they have recently ruled against to great criticism. Well, no. There are 4 characters in that ad. There is a man who goes on some sort of extreme adventure at the beginning. There is a man who goes to space. There is a man who achieves athletic greatness against all odds. We probably wouldn't have used that part in South Africa. And there is a woman who is sitting on a bench with a pram. Do you see the problem with that ad? So that one I have sympathy with why they ruled against it. I do think that it's entrenching gender stereotypes, and I must tell you that I practiced the speech to time it in front of my 9-year-old daughter. And when I got to this part and I said, "Do you see the problem?" she said, "Oh, I do." Okay, let's have a look at this one. This one is a little bit more difficult.
New dad too.
Wow, look at this lunch.
Yeah. Oh, cheers. Oh, this is good. That's the bit healthy. Let's have fun.
More ways to enjoy a tasty lunch. Beds open.
Okay, the decision here that this is negative gender stereotyping because it implies that men cannot look after their own children, and by implication that it is a woman's job to look after children, and that really you shouldn't leave your children with the men because they'll put them on the conveyor belt at the restaurant. I think you could equally argue that this is an ad trying to show men in an alternate role, trying to show that men can look after their children and can go out with their children in their arms, and they might make a few mistakes along the way, but they'll rescue the child at the end of the day. So I don't know that this one, they ruled against this one as well. I think that one, the decision would have gone differently here. Just as the dialogue around gender changes and evolves, so too do other dialogues. And for me, part of the challenge we face as advertising regulators is that we have to speak truth to the fact that our decisions change over time. The mores of society, to put it legally, change, and we have to be sensitive to that. When the ad I'm about to show you came out over a decade ago, I think even closer to 15 years ago, the complaint was that it stereotyped men. Let's have a look.
Hi, I'm Shirley Jerome. People often ask me what the men are like in South Africa. Well, if you consider that more women are raised in South Africa than any other country in the world, that 1 out of 3 women will be raped in their lifetime in South Africa, that every 26 seconds a woman is raped in South Africa, and perhaps worst of all, that the rest of the men in South Africa seem to think that rape isn't their problem. It's not that easy to say what the men in South Africa are like, because there seems to be so few of them out there.
This ad caused an absolute uproar at the time. They had people in the parking lot at the ASA protesting against this ad. It caused such an uproar. And the ASA pulled this ad at the time. I have to say that I think if you showed this ad today, it has its finger on the pulse of current conversations. I think, in fact, it's actually quite restrained. If you look at the current conversations about men are trash, all men are rapists, this one's quite nice. It recognizes that not all men. At the risk of prejudging a matter that might come before me, because I suspect that this ad might resurface, I think that the discussion, at the very least, would be very different these days. Because things are changing. And it's not just the way we view things, it's also the way we communicate them. One of the most exciting projects this year has been the launch of the Social Media Code, which is Appendix K to the Code of Advertising Practice. The reality is that thanks to the foresightfulness of the original drafters of the code, the definition of advertising is actually broad enough that it encompasses all new forms of advertising. Unlike other jurisdictions, we haven't had to make a new section of the code to deal with digital advertising and then make a new section to deal with social media. That definition is so broad that it's encompassed everything. And the rules that existed therefore applied to social media advertising. But there was a struggle in how to apply them. So in a project with the IAB, we drafted a new set of rules explaining how the existing rules of advertising apply to social media advertising. The main thing that we looked at is the fact that advertising needs to be clearly marked. The consumer has a right to know whether what they are reading is the genuine opinion of an influencer or an opinion that the influencer has been paid to give them. And to this end, we introduced specific markers that you should have hashtag ad or hashtag sponsored. In the UK, sponsored is very controversial, but we have allowed it, that one of those things should appear on the advertising so that you know that it's paid for advertising. By paid for advertising, we mean any form of payment. It's whether you were given money to do that or whether you were given a thing to do that, or whether you were lent a car to drive while you did that, whatever it is, if you were given something, you are now an influencer, and you need to identify the material that you produce as #ad, #sponsored. In the middle of drafting these rules came this ad. The background before I show you the ad is that this woman is a powerful influencer. She has thousands of followers, and she had built up to the scenario we see here. She had a number of times before what we see here gone out and made it clear to her followers that she was drinking and driving. What's very interesting is after the whole campaign ran and they analyzed the comments that had come in over the whole time, only 4 people out of millions of responses had said anything about the drinking and driving. So she led up to this, and on the night in question, she made it very clear in her feed that she had been out drinking. And then she got into her car to drive and to live stream while she drove. I'm not sure which one of those two activities is more dangerous. And let's see what happened.
It's the young women. We should finally sign people. So this is my call to action right now. You're a singer, dancer, rapper. You can be the star that I'm able to look for. I need you to come on. So if you know any singers, dancers, rappers, DJs, that rap.
Note the comments that now come up.
A bit too small for people probably.
After this, she didn't reply to anything for about 24 hours, and when people contacted her agent, they said no comment. When she eventually surfaced, she explained that it had been an awareness campaign around drunk driving, and it was very powerful. It got a lot of media attention. I think it did make its point very well. But we got a complaint about it. And the question before us, because people were very traumatized by it, and they said it should have been identified as advertising so that we knew that it wasn't real, so we didn't get upset. And the question before us is, she was paid for this. According to our rules, she should have had to put #ad or #sponsored. But then it wouldn't have had any effect if you'd known that it was a staged event. And we said, in a ruling that I loved, I think maybe this room will be with me on loving this. It's the first time I've been able to use the word teleological since I studied jurisprudence, and I could use it in a ruling. And we applied the teleological approach. I had to quickly check while I was drafting that it was what I thought it was. And we said that the evil that the rule seeks to address is that consumers will be confused into thinking a fake opinion is a genuine opinion, that then they will go and buy the thing that was recommended because they think that it's a genuine recommendation. We said that that risk did not exist with this ad because this ad is not selling anything. And therefore we said that she did not have to use the #ad or #sponsored in an ad like this. Okay. Well, thanks to the Chicken Licken matter, consumers very quickly became aware of us, and we started receiving complaints from consumers in sufficient numbers very quickly. What has taken far longer is to see the courage of the brands, the lawyers, I'm looking at you guys, and the agencies to trust the unknown. It is only in the last 2 months that we are again seeing an increase in competitor complaints, bringing us up to the sort of competitor action that we used to see in the ASA. There are many ways that a competitor can use the ARB to gain a competitive advantage. We've seen the eruption at the ASA of industry wars, where one industry starts taking on its competitors backwards and forwards over all sorts of things, taking issue with the most minute detail, bringing complaints just for the sake of it. And in my previous life as a consultant, I've been involved with strategies where we lodge 5 complaints one day after another just to keep the other side really busy because the deadline's 3 days and they're not going to be able to do anything except respond to complaints. But that's not the sort of nonsense I want to speak about tonight. I want to speak about the genuine use of the ARB in matters that could have gone to court on an action for passing off. The ARB offers an alternative to the passing off action. It's wider, and there is no doubt that it's cheaper. At worst, if it fails at enforcement stage, you have a powerful document on which to base an urgent interdict or an interdict that supports your case. And I have now done what I've been scared of, losing my place and where I'm thinking. Okay, let's start looking at passing off. I think everybody in this room knows about passing off. You know that it's based on exploitation of goodwill or reputation. You know that it involves the passing off of goods as your goods, as those of your competitor. And you know that it involves actual or likely damages. Passing off is reflected in Clause 8 of the Code of Practice around exploitation of goodwill. And here we see the elements of passing off reflected in a slightly different way. You may not take advantage of the advertising goodwill of another party. There must be actual or likely confusion, and it must result in the diminution of advertising goodwill. The difference here is that this is not an absolute list. The wording around it is consideration will be given, and inter alia. Could we even be lawyers without the words inter alia? Arguably, it casts a much wider net for considerations of equity. But the real difference comes with Clause 9, which is the imitation clause. This bears a passing resemblance to a trademark action, and it could be used in situations where you're thinking of a trademark action, with the very useful difference that you don't have to have a trademark. It is there to protect any original intellectual advertising property. It does not need to cause confusion. You do not need to have a reputation to protect your property. And it also, and this is not something that has been well explored, and in fact it only occurred to me as quite significant as I was preparing this, does not have the parody exception that Clause 8 has. Let's have a look at two recent matters that we handled on this issue, and I have a feeling we have some of the lawyers involved in the crowd here tonight. This was the first matter that was considered by the ARB on the exploitation and imitation clauses, and as such it was very important for us to be clear exactly where we stood on this. What happened here, as you can see, is MAC changed their packaging. It used to be called MAC Boost, and they changed their packaging to be MAC Soft. And we all know about Stay Soft. The very important thing that I learned during this matter is you do not call these things fabric softeners, you call them fabric conditioners. So now I know that. Stay Soft took issue with this, and they decided to bring it to the ARB, which I think you will agree is quite clever. They would never have succeeded on a trademark action because the word soft was excluded from the registration. They would be very unlikely to succeed on passing off because there's little likelihood of confusion. There's very clear branding for the MAC and the Stay Soft. It's very unlikely you would have confusion. Their only hope was the ARB, and again what you see on the screen now is extracts from our decision. For the ARB, the decision always essentially relates back to the consumer. While passing off protects the owner of the intellectual property, exploitation of goodwill first and foremost protects the consumer from the confusion they might experience, and it does then to a certain degree protect the owner of the original creative work. We understand the query in Clause 8 to boil down to this. Would the consumer in the supermarket grab the wrong product thinking it was theirs, or would they see it and think that this new product had some relationship with their old product? If either of those requirements are met, we felt there is exploitation of goodwill. In the MAC matter, we found that the bold branding that I pointed out before made this unlikely. And there was no evidence before us, we felt, to shift that perception. You can, in a matter like this, put evidence before us to show that indeed consumers are actually confused. We didn't feel that the evidence we had before us in this matter did that. However, on imitation, things went a bit differently. Step one was the finding that while the look and feel seemed very close, it was only the word soft that was an issue. And the reason for this was because The look and feel of the two products prior to the introduction of the word soft was already very close. All those things that immediately strike you, the shape of the bottle, the shape of the label, the colors, all those things were already there. The complaint was essentially about the use of the word soft. We were not going to be the people who said that you cannot use an ordinary word with its ordinary meaning. Not going to go there, not going to get ourselves sued by going down that path. But we did feel that the word soft here was used in a very particular context. It was not just the use of the word soft. It was used in already very similar packaging, with a very similar appearance, and it was of interest to us that it happened for no explicable reason. The only reason we could see that the product suddenly changed from being MacBoost to MacSoft was to bring it closer to the market leader. I want to also pause here and say that in practice, one of the things to know is that a defense to imitation, a good defense, is to give us an affidavit saying that there was no imitation. The problem is, in a case like this, it's going to be very hard to convince us that you suddenly took on a word that is part of the name of your main competitor and you had no knowledge that that was the case and it happened by complete coincidence. But there are matters where there is a very close imitation that happens just because two people are working on different ideas at the same time. This was not one of those, I don't think. Okay. For me, the hard part of understanding these clauses, when I'm grappling with actual real examples, it's getting my head around what it means to the consumer. And for me, this is how I understand it. Clause 8 is talking about the consumer being confused into thinking that the brands are related to each other or are the same brand now. Clause 9 is about the future. Clause 9 is saying that whereas before, and I will use Stay Soft and Mac, whereas before, if someone had clearly exploited the word Stay Soft, it would be clear they were exploiting Stay Soft. But because of the imitation, the Stay Soft and now the Mac Soft, any future exploitation of goodwill, it won't be clear whose goodwill you're exploiting, because the imitation has now diminished that goodwill and it is now split between two. And that's how I've grappled with it in my head, and given that I'm the one who will grapple with your matters, perhaps that's the way you should grapple with it in your heads. What you do have to remember is that Clause 9 only extends protection to original intellectual thought. In another recent matter we've had between Shoprite Checkers and African Cosmetics, we found that while this original product here had a very original idea when they came to market, apparently for a long time they were the only scented tissue oils on the market, something like that. They were basically a category by themselves. They didn't use a very original packaging when they did it. And when you compare what they did with this packaging to other tissue oils and other cosmetics, let's be honest, I'm sorry if the designer is by some chance in the audience, it looks like every other cosmetic on the shelf. And that meant, and I'm sorry about this bad slide where I didn't delete a picture that I should have, that one up in the corner is not supposed to be there. It meant that when it came to protection, there was nothing to protect. We stopped the inquiry at there is no original intellectual property here, therefore we cannot protect it with Clause 9. As we wind up for this evening, I want to bring you back to the idea of courage. I want to remind you that while I am in the business of regulating advertising, and you would think as such I don't like anybody to push any envelopes, it is vital to society that advertisers do push the envelope in the right direction. As much as advertising can be a source of harm, it can also be a force for good. And I will leave you with this example, which I believe is a magnificent example of the correct, of the correct use of advertising.
Is this the best American yet? Is it?
what I actually think she's trying to say.
Making the same old excuses.
Boys will be boys. Boys will be boys. Boys will be boys.
But something finally changed.
Allegations regarding sexual assault and sexual harassment.
And there will be no going back. Because we believe in the best in men.
Men need to hold other men accountable. Us, we. Come on.
To say the right thing. To act the right way. Some already are. In ways big
You're men. You're everywhere.
and small. But some is not enough.
Someone treat each other, man.
Because the boys watching today will be the men of tomorrow.
It makes me cry every time. Thank you. Questions? Professor D.
Gail, clause 9, don't you think that the underlying principles are more akin to copyright infringement than to any form of trademark infringement possible with things like imitation, originality, not having to be confusingly similar? That's, you're talking almost pure copyright.
And I think often in practice it's very much
Just want to repeat Owen's question.
So the observation on the question is that it's more like copyright infringement and then like trademark, the imitation clause. It's more. I'm going to take this also, I can pass it to the questioner. I think in practice, in fact, that is even often actually sort of physically true, because often we are dealing with actual copying of words. So often it is instead of copyright, to you quite right, but without the defences that copyright has. Although I suppose the defences could still apply in certain situations. So if you had an ad that used it for education purposes, would it work, but not if you were copying someone else's ad? It's an interesting comparison.
The fact that the defences aren't there is one of the reasons why we go to the housing regulatory board.
Do you hear that? Do you hear that? I think I have come to the housing regulatory board. Professor Dean says so. Anyone else? You'll be nice and loud. And we are having drinks and eats, I believe, afterwards, and if you want to ask me something afterwards, the only thing is for the system.
Well, I think you will agree. All I can say is, drat. My dastardly plan didn't work. She's actually pulled it off. Right? So, thanks, guys. Just a little gift as a token of our appreciation.
And don't forget my poster.
And the poster. So all that remains for me to do is to thank Gail for taking the time out of her busy schedule. I mean, running the show at the ARB is no joke. For taking the time out of your busy schedule to come down. And interesting stuff. I mean, there's no doubt about it. I didn't think we were going to go to some of these places, like you say, and food for honest conversation, really thought-provoking stuff. I'd like to thank Von Seidels again for being our partner in presenting this evening. And as Von Seidels, you will have learnt a valuable lesson. There is no budget big enough that Annette cannot spend. Right? Right, so you've learnt your lesson. Say skrik vir niks. Right? So if there's money available and you're struggling to find a cause for it, you know, Annette is willing to help out. But also, I must thank other colleagues in the faculty without whose efforts this won't be possible. This function takes a lot of organization and cooperation from all quarters. The Dean's Office, Querbus for the social media and designing the poster, people like Gerda and Kathy. As I came in with Gail this afternoon, they were feverishly cleaning the venue because there'd been a whole day of lectures, and there's sort of no crisis that they can't deal with. And we must thank the caterers. And last but by no means least, I'd like to thank you for attending, because you make all our efforts worthwhile. To see you turn out in these numbers really encourages us to have more public lectures, to have the public engage with what we do here at some level is very important. So please join us in the quad for something to drink and eat. Thanks.